that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when he says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Just for the state attorney not to put that in there, the italicized portion, where Supreme Court is giving instructions to the court with those comments, for them not to put that in there, I disagree with.
Okay, well, the Jackson case speaks for itself, and the court has reviewed it.
Thank you.
All right, thank you both for your motion, your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response, that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion, as under the Bush case cited by the state, law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is the expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted, and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regards to the court's ruling? Questions or clarifications with regard to the state's ruling, or the court's ruling, excuse me. All right, that takes us now to the state's objection and motion in limine to exclude decedent's medical records. I've reviewed that as well. State, you may proceed.
Just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from two incidents, one in 2017 and one in 2018. The third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I've not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment. That narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that he, the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages of discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe are incriminating to her.
Understood. But respectfully, that's not the issue before the
I
court right
understand
now.
that. But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, Jorge Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have Jorge Torres' medical records prior to me sending them to you? All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on Jorge Torres' medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that, but they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be.
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony.
You are the proponent of the evidence. So you have to establish relevance.
I agree.
And you have to establish that it is not so substantially unfairly prejudicial
Yes.
that the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that. What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down since
Well,
we have some level of common ground here?
My case is not going to be presented, I would assume, until next week. So I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well,
by
the state's
Friday.
position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure
Right.
there. I'm relying on counsel's representation.
I don't know. I'd have to look at them, but in one of the medical records, George Torres was over a 0.31 BAC. Every
In
time,
2018?
2008,
I'm talking about the 2018 incident with regard to the plate
I
glass
have to look at
window.
the records, but there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk. Or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a 0.3. When he gets over a 0.2 to 0.3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find based on that whether or not that's relevant and probative to the case.
That's not how motions in limine work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be, some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
That's it.
Response?
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records And I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, Third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Miss Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case, or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both, and the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day. And that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance. So I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right. Any clarification or questions with regard to the state's rule or the court's ruling? Defense. All right. Thank you. That now takes us to the objections to the evidence. Give me a moment. We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's 5th amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their 5th amended as I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A, and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item, tracking their 5th amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's 3rd amended exhibit list. When was the 5th amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left. So I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a 1-page document. So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay. All right. I need clarification, Mr. Owens, as to when the 5th amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed. We're checking on that. When it was filed. What was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's 3rd amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else.
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second. Okay. All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return. Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3. That would have been yesterday morning, seat 48. Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around. The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when 2 of these panels, or at least one of these panels, has already been exposed to COVID up in the 23rd floor? Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in like sardines.
Response.
I don't know the layout of 23, so
Can you all approach just for a second? All right, court's going to take a 15-minute recess to address jury selection location this afternoon, and to give the defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objection to the, if he doesn't have COVID, then I don't have a motion for cause.
Okay. Any response from the defense? Correct. That is correct. I read you what was provided to me. Okay. Court's going to be in a 15-minute recess. Thank you. We're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State. Ms. Boone is still seated at council's table wearing the same gray suit and white blouse from this morning. Can y'all approach? All right, court's going to step out for 1 second, and then you can email that exhibit list to Madam Clerk, and then we can go from there. Thank you. All right, we're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State, let me get appearances.
William J. for the state.
Defense.
James Owens for Ms. Boone.
All right, thank you. Ms. Boone is still seated at counsel's table with the same clothing from this morning. All right, I've been provided by Madam Clerk defendant's fifth amended reciprocal discovery exhibit list. I haven't had the opportunity to review it yet, but it is in my hands. Let's start with the defendant's objections to state's digital exhibits. I'll turn it over to you, Mr. Owens.
Judge, and I did want to say that the notice of provision of defendant's fifth amendment exhibit list was e-filed on October 3rd. The fifth exhibit list was emailed to the state on October 3rd.
Correct. But the same problem I have is it's just the notice of provision. I don't know what any of the substance was. All right, you may proceed, sir. Okay, go ahead.
And Judge, this was a little bit of a new procedure because what I did was review the images and these, as in the motion, we object to all the cell phone photo evidence. The state intends to introduce a trial as to, I'm not going to know until I hear evidence or see when they're trying to introduce it, if it's relevant or not at that time. Something might make something relevant at a certain time, or it might not make it relevant. So there. And also as to just the foundational stuff, because the images, as I've seen it, I don't have dates. So I don't know when it was taken in relation to the February 23rd, 2020 date, which is the date of the offense. And so I'm at a loss for that. So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So that's going to be, if the foundation is laid, that's my problem with these photograph exhibits, is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay.
Response?
Is this going to be considered a separate hearing for the record? So should this be D or should it be A?
Everything was, when I called what was being heard today, it was all in the same hearing. So I believe it should be pre-marked as D.
What I'm having Madam Clerk mark as D for identification for purposes of this hearing is what has been provided to the defense as the very narrowed down portion of the phone extraction carve out. What it has is what, and we were even so specific that we labeled one part of the PDF case in chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108. Attachments that go to the case in chief timeline. Count up as 80 photographs and videos. Attachments and rebuttal. Count up as 147 photographs and videos. There is metadata that comes with all those files. So there is a date stamp and time stamp on each of those files. For instance, 12/25/2019, 1:10 p.m. Another one might be 10/26/2019, 6:06 p.m. They all have file names. Providing context would be the PDF outlook or PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this as states 4 for the purposes of these hearings.
Any objection to what was pre-marked as D? All right, that will received without objection as states 4.
So just to give the court an example, on page 49 of 59 of the PDF labeled case in chief, entry 31107 in this PDF from the phone extraction is labeled videos, 2/23/2020, 11:12 p.m. 45 seconds, UTC -5, which means corrected to Eastern Standard Time for that time of year. And it's image_1062.mov. So that sort of information is going to be there for the majority of these files. The ones that end up getting recovered from unallocated deleted space are sometimes not going to be there. But there will be contextual clues as to their relevance. The court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase that started at 11:12 p.m. 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the timeline. And what we have carved out is the case in chief timeline has a conversation that begins on Christmas of 2019, and it starts with Mo, presumably the decedent's brother, having a conversation with Sarah Boone, the owner of the phone, and it culminates in hide and seek, I shall. That's the context of that conversation on December 25th. Then it goes down to conversation that's going on January 12th into the 13th of January of 2020. Culminates in a text from the owner of the phone saying, "And bless you and all of you too, I'll get capitals rid of him." So that's the context of those portions of our case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is, again, 108 pages. It starts, and it basically involves with conversations with or about the decedent, conversations with his family, which I anticipate the defendant is going to testify she was terrified of, and there was problems with all the time. It's going to give some context to those things. It mentions when they became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, case in chief and rebuttal, are the ones that are associated in these time frames. I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child, any of that child's friends. There was no need for any of the pictures of the children. It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, you know, one might expect there to be pictures of injuries. Instead, there's pictures of art. So we did our best to select which photographs and videos were pertinent within these timeframes. We did our best to narrow it down to what timeframes we set. We believe will give a good rebuttal picture after she testifies about his family and her relationship with him. So that's where we're at. So as far as like the relevancy, the general relevancy objection that was made, there was no specificity as to what particular entries in the PDFs are objectionable for any particular reason. We believe that everything is relevant. Again, we are submitting it for the court's review. I know that we're on the third day of jury selection, which will apparently resume in 81 minutes. If there's an authenticity issue, because one of their objections was relevancy, foundation, unknown origin date, hearsay, and Crawford issues. I'm submitting for the court, if I can approach the court. Gilbert versus State, 324 Southern 3rd, 598 from the Second District Court of Appeal, decided in 2021. Lamb versus State, 246 Southern 3rd, 400 from the Fourth District Court of Appeal, decided in 2018. Gale, G-A-Y-L-E versus State, 216 Southern 3rd, 656, Fourth District Court of Appeal case as well in 2017. The basics of these three cases are just the very low bar for authenticity. As Professor Earhart from Florida State University would tell us, authenticity is a very low bar for the court. It is generally considered a matter of weight for the trier of fact. And with this digital evidence, it can be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress, and it was provided to a digital forensic examiner who was able to use the defendant's passcode to unlock it and perform a digital extraction. So that should clear up most of the authenticity issues as to who the owner of the phone is. The state readily concedes and has provided context by using extra pages of conversations that at some point the decedent no longer had his own phone and was using Miss Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women. But I believe the context of those conversations makes it clear who is using the phone and who is not using the phone. So we believe that there is no foundation issue. We believe, based on the defense they are raising, that there is relevancy. We have split it up to the case in chief and the rebuttal. We are specifically only entering the two incriminating statements in the context of those incriminating statements about hide and seek and getting rid of him, plus the timeline of the date of the offense. Then the rebuttal, we have carved it out as best we could to present a picture of the conversations and the tone, as much as tone can be inferred from texts, and how the relationship was with the family and who may or may not have been the psychological aggressor. As far as hearsay and Crawford issues, I am unclear if they are talking about just in general the digital forensic extraction report itself. One of the cases I gave to you makes it clear that machines are not humans. They do not get subjected to Justice Scalia's version of the Confrontation Clause that he outlined in Crawford versus Washington in 2004. What he also talked about, though, and what has had some discussion since the Crawford decision, was what's hearsay versus testimonial hearsay. Obviously, there's no testimonial hearsay in these phone extractions. There's no implication that any of these statements made by any of the participants in the text conversations were doing so with an eye towards litigation or prosecution. So it's the state's position, number one, that the extraction itself and all the data that is coming from it is not hearsay and is not testimonial hearsay, much less. And the conversations that are going on with the other people, the statements that other people are making back to the defendant in the carve-out that we've provided aren't being offered for the truth of the matter asserted. There is no hearsay issue. It is to provide the context of things that the defendant is saying. I'm going to go bond Jorge out. I'm going to go to the public defender's office and get this taken care of, or screaming at his family, so on and so forth. Demanding immediate responses when somebody's cutting hair and keeps on telling her repeatedly, I can't respond to you. I'm working. So those sorts of things, it's the state's position, aren't being offered for the truth of the matter asserted. As far as the unknown origin date, I think it's pretty clear from the PDF timeline that there is a date and timestamp to every single entry from this phone extraction, and that corroborates with the images, most of the images, some were from unallocated space, but it corroborates the metadata for these images. So we're asking for that their motion or their objection to be denied preliminarily. Obviously, we have to lay the predicate properly at trial, but now the court has a copy, and hopefully we can get advice from the court if the court is believing that there are sustainable objections before we swear in the jury, so that the state can pull any photographs or videos, or we can have at least a discussion about those specifics. And then after discussing those specifics, the state can pull those out before burning a DVD to provide the jury. We also have the ability to black out entries in the PDFs. Again, no specific objections were made, so it would be our position that they're waived. There was a generalized objection, but so that we're not doing this when the jury is out. Trial is busy enough, trial is tedious enough to not be conducting discovery and doing redactions during the nights and mornings of trial.
Thank you. Response.
Judge, I think this procedure calls for a lot of speculation as to the defense part, as to what these photos, examples of the photographs, what's the use of this photograph? There's a piece of art on the wall. I don't know how that's relevant to the case. So without knowing how it's relevant and what their theory is of it being relevant, I have to form the objection. I don't think this is relevant.
What's your response to the lack of specificity, that these are just boilerplate objections to all photographs, all video?
Yes, well, they're not to all photographs and all videos. There are things that we list.
It is an objection to all cell phone photo evidence the state intends to introduce. It is
Correct.
objections to all cell phone video evidence the state intends to introduce.
Because at this point in time, Judge, I can't tell you what the independent objection would be. I don't know how it fits into their theory of the case. That's cause for me to speculate how it fits into their theory of the case. How can I do that? If they show you a picture, like a picture of artwork, all right, I don't know how that's relevant to this case, or a conversation that takes place between two other people. At the time, I don't know how it's relevant to the case. So what am I supposed to say? No objection to it? And then am I later barred from objecting to it when I don't think it fits, or they hadn't laid the foundation to get it in? It's putting the cart before the horse.
That pertains to the rebuttal evidence. What about the evidence that was outlined that the state intends on using in its case in chief?
That's it, Judge. How do I know they are going to be able to lay the proper foundation for that evidence? How do I know? That's the thing well, I think the procedure goes like this. Yeah, I could be wrong, but I don't think so. The procedure goes like this. The state has a piece of evidence. They have that evidence identified to someone. All right? They get it marked as an exhibit. Okay, at a certain point in time, the state asks if we'd like to introduce exhibit number 1 into evidence. Defense, either objection or no objection at that time. I've heard the witness who've identified it. I know what it is that time, and I have some relationship to it at that time to make the proper objection. Just getting a picture now, and I'm supposed to say no objection. I don't know what they're using it for. Guess what, Judge? The videos of the suitcase, we didn't object to those. Do you know why? It was clear. I know when it was, and I know the purpose of using it. But when you have animate objects on the wall or pictures of individuals, and in this case,
But what I'm reading, it sounds like you're objecting to those. All cell phone video evidence that the state intends to introduce.
correct.
Sounds like it covers the suitcase video to me. All
No, it
means
doesn't.
all.
The suitcase video is listed in the things that we don't object to.
I don't know that. I have image underscore 0954. I don't know what that is. Image underscore 0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well, what the state is asking for is a preliminary ruling on these objections.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court for evidence being omitted?
State conceded they need to lay the appropriate foundation.
Well,
Part of their argument.
okay.
So I'm not going to address foundation. If they're able to establish it is what it purports to be under the case law, under 90.901 and everything else, I mean, he's right. It's a low bar for what admissibility is.
And I have no problem with that.
Okay.
I have no problem with that part, Judge. The thing that I'm saying is, I want to make sure, because I didn't object to something on here, it waives my right to object to it later.
Okay.
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this on the state's list of exhibits. You did not object to it. You can't object to it now. I don't think that's fundamentally correct. So I don't know what part I'm missing.
Anything else, sir?
Well, yes, Judge, I would like, because I know it's a different jurisdiction. People do things differently, okay? 30 years, I've never had to do this in a criminal case, okay?
Part of the reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se. And we need to establish deadlines to prevent any ambush or last minute issues. Then y'all parachuted in on August the 30th.
Yes.
There was no order. There was no request to vacate any of those deadlines. So those deadlines were still in full force and effect.
Yes, sir.
But the reason behind that was because Ms. Boone at that time was representing herself pro se. And to avoid issues at trial, the court had set a schedule for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I'm deemed to have waived anything. I get it. But the state's proffer seems to have established some level of relevancy for these things. And as we well know, the bar for relevancy is very, very low. As the foundation, I agree with you. And the state concedes that point. They need to establish the appropriate foundation. And if they're able to do that, I'm not foreclosing you for making objections. But as of this point in time, your objections are preserved for the purposes of trial. You can raise them, certainly. But at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant and not repetitive.
Judge, at this point in time, as a pretrial ruling that doesn't waive my right to object to something as they're trying to admit it based on relevancy, foundation, or any of those things, then I don't have a problem with that. what my concern was, the way this looked like to me, if I didn't make an objection to it at this time for this, I am waiving it at trial.
I understand. Any clarifications or questions with regard to the court's ruling?
We're just, I believe we're trying to treat this like a video interview redaction issue. Like, it takes time to go back and pull out pictures and pull out videos or black out lines or remove pages. That's all we're trying to do, is do that today. I don't know what the defense expects to be different at trial, what more information they're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Miss Boone's apartment. It's right on the nightstand next to the suitcase. And then that person's going to have to testify, well, I gave it to Junella Wadden. And then Junella Wadden is going to come in and bring the phone with her and say, this is the phone that I plugged into my Magic Cellbrite software or whatever she used on that particular day. And this is how Cellbrite works. This is my educational background, blobbity with this software. And I pulled this extraction out. Mr. J sent me this carve out of this extraction before trial. In fact, she picked it up yesterday. And I believe, I'm going to testify that this is part of the larger carve out. This is from her phone. That's going to be the foundation. The rest of these things are things that we should be able to have an intelligent discussion about today with specificity about this line of text isn't okay. This particular photograph's not okay for this reason. That's what we were hoping.
Okay. Have you reviewed what it is that the state intends on eliciting in this exhibit?
Yes, Judge, this is the things that I reviewed. I sat down last night and went through every one of them preparing for this hearing. What we did not, or what we failed to do because of the time restraint, for the ones that we didn't list a number and I didn't give detail as to, like, IMG 0954, what it represents. My concern is this, because I don't have a problem with this or with the state's evidence at this time, as long as it's not a bar that when we come into court and I feel something is not relevant at that time, or they go to admit it and I say objection relevancy or objection foundation, then I'm not barred at that time. I don't know any rule that would bar me at that time.
Okay. I'm going to overrule your objections for the reasons that I previously identified. You can raise your objections at trial if you deem necessary, but based on the state's proffer, I'm going to find that the different categories of documents that he's identified as reflected in Exhibit 4 are relevant. They are not repetitive. They are not cumulative. And so long as they can establish the appropriate foundation, and based on counsel's proffer, seems like they might be able to do so. Any questions, sir?
Now, I just want to add something for the record.
Yes, sir.
The state during its proffer said there were no photos of the child. That's not correct. There are photos of the child.
That are being sought into evidence?
Yes, Your Honor.
State? Response, if any?
I don't believe so in either of the folders. I don't have any independent recollection if I tied it up more than when I gave them what I believe the exhibit to be a week or two ago, but I don't see any. Okay, I see two images. I couldn't recognize it as reflection of children in I don't know if it's a snow globe in an aquarium or whatnot, but I have no objection to removing those two. I just didn't recognize it as children. I recognize it as a crab.
I haven't seen the picture, so I'm at a loss.
Well,
I'm sorry,
it's an
Judge.
extraordinary file name, but I'm going to remove those two
Okay.
exhibits that they're
I'll
talking
take care of that issue for you,
That,
sir.
that takes care of that issue, Judge.
Okay.
But the point that I'm trying to make with that and why I raised it is that there are going to be certain things that I'm not going to know into what is the purpose of it as far as how is it relevant now? They can make a proffer. I understand they can make a proffer, but their proffer isn't evidence. Once it goes up, the witnesses and all, and the court has told me that I don't waive my objection, so I understand the court's ruling.
All right, thank you very much.
Yes.
Anything else with regard to the defendant's objections to state's digital exhibits, Mr. Henderson?
No, Your Honor.
Okay. Moving now to the defendant's fifth amended reciprocal discovery exhibit list and the state's objections to same. There are some for which the state has no objections. Those need not be addressed. It will just be dealing with the objections outlined. It is not lost on the court that it is 12:30. We do have a jury coming in an hour. My court staff does need a lunch break. So how do you want to proceed, Mr. J?
I just want a ruling before we swear in the petite panel.
Okay. Do you have any concerns with proceeding with jury selection this afternoon and the final portion of the court's inquiry? as addressed yesterday and turning it over to you without having a ruling on these, and we could address these objections tomorrow morning before we bring in the balance of our panel. All right, is that acceptable to the defense? Okay, all right, so then here's what we're going to do. We're going to be in recess till 1:30. We will report to the 23rd floor. I've already advised jury services and court admin that a room is available for us. We will continue jury selection at that time. I will keep you apprised of whether or not we can continue jury selection in 23 tomorrow. As soon as I have that information, I or my judicial assistant will pass it along to you. Assuming we're in 23, we will advise the jurors when they need to return, and we can address all these objections tomorrow. And we'll address those objections either in 23 or in 12 alpha. Anything further from the state?
No, Your Honor.
Anything further from the defense? Okay, we will see you all at 1:30 and 23. Thank you.